So now we're going to talk about some specific additional issues that come up with AI. And this is really one of the most interesting, I'll call it from a philosophical standpoint. This gets into the question of AI and inventorship. And I have to start by giving credit to my son, who wrote a piece about this in 2019, but pointed out to looking at it from the standpoint of the future, where we may be going with this. So when we talk about novelty, the newness we talk about in inventive step, they're related. Novelty asks whether invention was previously made and become part of the prior art. There has to be a single piece of prior art anticipating each part of the claimed invention. This can be very complex, and we'll look at one AI-related patent, and you can see how complex it is, because AI inventors may seek patents on what I'll call fairly general claims and disclosures, which is going to make it very difficult to determine whether a piece of prior art has actually anticipated subsequent AI inventions. Now, this is a problem that's arisen because of AI. It's not such an unusual problem from a philosophical standpoint, because there are other areas where it's hard to identify what the relevant prior art is. But the more interesting set of issues is with respect to inventive step. That is, the distance between the claimed invention and prior art, and whether that would be obvious to a person reasonably skilled in the art. So let's talk about historically, which is only 20 years ago, old history, right? When we ask when something was invented, we ask whether the human being who was claiming to have invented did something that the average, reasonably skilled human would not be able to do, right? Whether they made a leap that was beyond the obvious, okay? That's the old standard. Now we're getting to an area where, and I don't know how much you use AIs, but they continue to amaze me in the capabilities for doing things like legal research and scientific research and the speed at which they do them. And I talked about how sophisticated they've become in inventing. What if AI solved technical problems more easily than humans? Do we need to change our inventive step standard and compare a human to a reasonably skilled AI? Because what if an AI could do something very easily? I mentioned that it took a human PhD student maybe a year or their whole PhD career to make one folded protein. Now DeepMind could quickly make all folded proteins. So do we say that the individual human was invented when we now know that an AI could do that without any trouble at all? So is what the human did invented? Do we compare them to another human PhD student? Or do we compare them to DeepMind and what the AI could have done, right? So maybe it becomes a lot harder for a human being to get a patent because a reasonably skilled AI could have done it very quickly. Or should the AI be off limits? We won't compare humans to AIs. Well, what about if the inventor, and we'll leave aside this question whether you could name them, should an AI be compared to a human or to a reasonably skilled AI? So now what if we're asking the question, well now we know the AI is smarter than the human. Do we still compare the AI to a reasonably skilled human? Or do we ask, do we compare the reasonably skilled AI to another reasonably skilled AI? Or the AI inventor to a reasonably skilled AI? Right? Who are we asking, is this invented? Are we asking whether compared to a human or whether an AI should be compared to another AI. Is there a super smart AI that's better than the average AI? How do we determine whether something's invented for an AI? Now, one of my son's hypotheses is that, and again, you have to look at the arc of progress at AI. He speculated that in the not too distant future, pretty much everything is going to be obvious to AIs. They'll be able to solve technical problems without any difficulty. And then do we need a patent system at all? Because AIs can basically solve everything very quickly. Well, that's a more philosophical, future-oriented question. So maybe we won't need this inventive step idea. But this question of what we compare when we're asking whether something's invented, is it compared to a human or is it compared to an AI, is one of these questions which the patent offices are now working on. Right. What about what we do? So here's another problem area when we look at AI. Enablement and disclosure. Again, this is more addressed to patent lawyers than necessarily to the general students, but why do we give people patents? We give them patents in exchange for disclosing their invention to the public. I mentioned you have to put it in the specification. We'll look at one of those in a minute. And what does a disclosure need to do? It needs to enable, that's the key word, a third party to replicate the invention without undue experimentation. So there's a lot of jurisprudence on that. What's undue experimentation? So if you give someone a patent and it takes them 3 or 4 months to make the same thing per your disclosure, and they have to try 4 or 5 different ways, that's generally not undue experimentation. We don't require that your patent be so clear that they can just do it instantaneously. But if it takes them 2 or 3 years and engaging in a research program to replicate it, that is undue experimentation. So you have to teach them reasonably well how to make your invention. And then, and this is even a bit more technical, show that the inventor was in possession of the invention at the time of the patent application. Now why is that important? Well, I mentioned that idea of the competing patent applicants, right? That the patent goes to the first inventor. Well, patents are so valuable that sometimes companies will use the term jump the gun, like to file their patent application before they've actually finished completing the invention, right? So that they have an advantage over their competitors. So it's a very important part of the patent process that when you submit the patent application, you've actually completed the invention. And the technical term patent offices use is they have to be in possession of the invention at the time they file the patent application. Now, so those are things you'll have to do with respect to AIs as well. And you have very specific rules involving the drafting of patent claims. So how do you know what is patentable? Well, we'll look at a DeepMind patent on the next slide. But a patent starts with a general description of the invention. Well, first it starts with some technical details about the dates and the inventors and the assignment and so forth. And then it describes the problem. And then it has an abstract that says that here's what we generally did to solve the problem. And then it goes through a detail, then the specification contains details about here are all the steps. So this could be quite lengthy, it's quite technical. And then they have drawings, particularly if it's a mechanical device or a chemical device. See, here's what this thing looks like in a pictorial form. And then when you get to the end of the patent application, there's something that says, and here is what is claimed. And then the real technical part of patent drafting starts when you have to define the scope of your claims. And this is very technical language where you set out precisely what it is that your invention does and what the limits are of your invention do. And most of the time patent offices spend analyzing your application is spent analyzing your claims. Because when you go to litigate a patent, you're not litigating typically the whole patent. You're litigating this narrow set of technical descriptions of what the patent does. Well, then you get, well, how do you do that when you're talking about something like an AI software program? How do you describe very briefly the operation of a computer program in language that can be very concise? Now, again, I'm not expecting you're all going to become patent lawyers, but one of the principal ways we do this is with something called a means plus function claim. And a means plus function claim simply is a statement that we are, you could say, we have a computer program that will solve this algorithmic problem using the structure described in the specification. So you describe what you're trying to do, and then you say that exactly how you're going to do it is described in the body of the patent application. It's called a means plus function. That allows you to be more general because you can describe the program in the specification itself rather than narrowly in the claims. The problem with the means plus function claim is that once you've made a means plus function claim, you are limited in your patent to precisely what's described in the specification. Now, I'm not going to go into that much more because it's pretty technical, and unless you're really a patent drafter, it's hard to understand why that's so difficult. But in any case, I'm going to show you a patent in a minute. Now, AIs are primarily software programs, right? So, computational formulas and so forth, how you reach a particular conclusion. Some of them, so if you take NVIDIA, the biggest GPU maker for AIs, their patents are not just on the hardware for the GPUs. They have an enormously complex system of computer software. They have what they call it the CUDA system, and their hard microprocessor technology, and they work together. And they have patents that cover both the computer software side of the invention and the hardware side of the invention. So if you are a potential competitor and you're trying to make the thing that NVIDIA makes, you have to be wary of infringing both their computer software patents and their linked computer hardware patents, and this creates a tremendous barrier for NVIDIA. One of the reasons it's so difficult for people to compete with NVIDIA is the patent network they have surrounding the combined hardware and software complexes. Now, when we look at the history, and I'll come back to this a little bit when we discuss software, originally, both patent applicants and software applicants, but let's say patent applicants, thought they'd have to just provide the source code, right, to the patent office. So why is that a problem? Let's say you're Microsoft, someone who's making computer software, and you want a patent. And what you give to the patent office is many, many lines of computer code. And it may take the patent office 2 or 3 years to finally grant you your patent. By the time that patent is granted, you will probably be using a much different computer software code. And somebody could make that new code without violating your own patent, because your patent disclosed the original source code, not the source code you're actually using 3 years later. So the software companies initially didn't really rely on patents because they didn't understand how they could simply disclose some code and then 3 years later prevent somebody else from making the same thing if they weren't using the same code. So they overcame that problem. Instead of just disclosing the code, they started disclosing, and for those of you who are in the industry, they started disclosing the flow charts and the diagrams of how the computer process worked without tying that to specific code. They said, here's the flow of our program, here's what it's intended to do, so that could be a means plus function claim, and they were able through drafting to overcome the initial problems with patenting computer software such as AI, and they are doing that now. But it took a long time to actually figure out how to do that. So I'll start by describing this to you and then I'll show it to you. So if you look at DeepMind, right? DeepMind is the Google company that does the advanced AI. You're probably all familiar with that. They have now a separate pharmaceutical branch called Isomorphic. But they're the ones developing these folded proteins with their computer model. And if you look at the patent, you'll see it's a method patent that describes processes used to predict folded protein structures based on amino acid sequences. So they take the amino acid sequences and then the computer extrapolates from the amino acid sequences to create the folded proteins, and they do this through what they call an iterative process, which just means repeated. They repeat it many, many times. They give different values to the results, which ones seem to be most robust, and in the end, they end up with a model of a single protein, but it's a predictive model, and they use qualitative scores for the outputs and so forth. So far, not too many patents have been granted about this, but I'll show you just so you have an idea. And of course, it is in your materials. But this is just an example. So this is a patent application filed through the WIPO Patent Cooperation Treaty, or PCT system. And so you can see that the patent was published in 2020, filed 2019. The DeepMind Technologies, you can hear who the inventors are, so there you have the list of inventors. It happens that the PCT system, you get to designate the various countries where you intend the patent to eventually be filed. I'm not sure we'll have time to go into how the PCT actually works. Maybe on the last day we can talk about it a little bit. But here they give you what it is. Methods, systems, and apparatus, including computer programs for performing protein structure prediction and protein domain segmentation, and then it describes in more detail how that works. At each of a plurality of updated iterations, determining a gradient of quality scores for the current values of the structure parameters with respect to the current values of the structure parameters, and updating the current values using the gradient. And then it gives you a diagram of how you do that. Now then you would go through, this is just an excerpt. I've taken out the body of the specification, which is very long, 60 pages or so, of describing how all of this works in, like a better way of putting it, plain English. Then you get to the end, right? These are the claims. And you'll see this is quite lengthy as well. the claims, a method performed by one or more data processing apparatus for determining the final predicted structure of a given protein, wherein the given protein includes a sequence of amino acids, wherein a predicted structure of the given protein is defined by values of a plurality of structure parameters, the method comprising. And then it describes how you go about computing that method, and then you have, so that's what's called an independent claim, standing on its own. And then this claim number 2, the method of claim 1 wherein. That's something, again, this isn't of course on patent law, the method of 1 wherein, and that's called a dependent claim. So the dependent claim is reliant on the claim in claim 1, and it takes claim 1 and it narrows how claim 1 works into the dependent claim, which is claim 2, and then it has a lot of details about what the differences are between what went on in claim 1 and claim 2, and you would see that you have a 5th dependent claim here. So, in any case, I'm not going to go through all that, but then when you try to see, then I talk about the fact that you have diagrams and drawings about how all this works. So this is a DeepMind's program, goes about computing a folded protein structure. And I'm not going to go through any more than that. You've got it in your materials, but you can see that this becomes quite a complicated process, and it not only requires a human who is drafting, well, I can't even say that a human drafted those claims. In fact, today you can go online and find many companies that will draft your patent claims. AI is drafting patent claims for you. So I shouldn't overstate done by a human. Probably a lot of that wasn't done by a human. But you get the claims defined, but imagine you've got this 30 pages of patent claims which describe a series of iterative processes working with qualitative values of results of predictions of how an amino acid chain will translate into a folded protein structure. And then you're asking yourself, you're a competitor, how do I draft around Google's patent, the DeepMind patent? And you have to figure out whether what you're doing is different from what they just did. And when you've got these kind of broad claims, we use a neural network to create an iterative prediction and a qualitative score of the result, and then we refine the qualitative results. It becomes quite difficult to figure out whether or not you would be infringing Google's patent. Now, we'll talk a little bit about patent subject matter in a minute. That's a little bit similar to that, but only a few patents have been granted so far to DeepMind. There's many patent applications, but the patent offices are still working through them. But one of the things it requires, and it's hard to overstate this, it requires a human being patent examiner who actually understands that. There are not that many patent examiners with the expertise to understand a patent like that, and whether or not the patent should actually be granted. And now, of course, it won't surprise you to learn that patent offices are increasingly relying on AIs to determine whether or not the patent should be granted based on evaluation of the claim. So I'll note that, I think I say this later in the slides, that AIs may eventually be policing themselves and determining whether or not you're going to be granting patents on them. And as I mentioned, NVIDIA's is as difficult and complex as DeepMind, because NVIDIA is using both hardware and software combined to create this, we'll call it patent fortress. And lest you think otherwise, Chinese companies are they're the most active, the most AI patent applications have been filed by Chinese companies. So it's not like DeepMind and NVIDIA are out there filing all these patent applications. Chinese companies are very, very active in filing both hardware and software patent applications with respect to AI software and AI machines, right? So there's a lot going on in this area. But you can imagine how challenging this is becoming. And when we talk about quantum computing, that even takes you a step. This is, dare I say, simple compared to what quantum computing patents look like. And we'll get back to that. And how few people there are who really have the human mental capacity to understand a quantum computing hardware patent, which is its own challenge. Well, here's something I'll call the black box problem. You've probably heard of this concept. Now, even if you listen to the most sophisticated AI developers, the people at DeepMind, for example, they will tell you when we initially input this data into the AI, we were never expecting the result we got. And to be frank, they tell you, we don't know how the AI got to that result. We drafted a program, we put in the data, we connected the large language model, we told the AI to go do something, the AI did it, but we don't know how the AI did it. It just did it. We can't tell you in a step-by-step way how it got to the result. And that is actually not uncommon. I'm not describing that as a single event. This is happening more and more. Well then you say, well, if I don't really, so I'm filing a patent application. Let's say it's on my AI, or it's on my AI's result. Let's say it's on my AI's result. We had a question about the result. Well, what if I don't really understand how I got to that result? I know I've got that result, and I'm sure that that result is accurate, or I'm telling you that result is accurate, but the AI did it, not me. Now, as the patent applicant, do I need to tell you how the AI did it? Do I need to understand what the AI did? Or is it enough for me that I say I told the AI to go do it, and it did it, and here's the result, and it works? Well, as a practical matter, as a matter of patent law, you need to describe what you did and that it works, but you generally don't need to explain why it works. That is not a general requirement of patent. And I'll give you a simple illustration. Most mechanical inventions rely at some level on gravity. It's the simplest thing, right? The arm is going to drop. Why is the arm going to drop? The arm is going to drop because of gravity, right? I put a weight on it, it drops. It's gravity. Well, then you say, well, how did gravity do that? What is gravity? And they say, you don't know what gravity is. You know the law of gravity, but we can't tell you what gravity is. This is the world's great mystery. What is gravity? We don't know the answer to that. I'm not going to explain that to you today, but if you try to figure out, why don't we know what gravity is? Well, we've been working for 200 years to figure out what gravity is. No one knows what gravity is. We know the laws of gravity. We don't know why we have the laws of gravity. So we don't need to tell you that gravity works because it is a force field that's generated by dark matter that arises from the bodies of extinguished stars. We just need to say the gravity functioned when it did it. So we probably don't need to tell you why the AI did what it did. We only need to know that we programmed it, it did it, and it worked. So another example, because this ties into biotechnology, and I'll go a little bit faster. When someone like Harvard says we genetically engineered a mouse for a predisposition for cancer, and we did that by modifying the genetic code in this way, and the result was a mouse we could use for pharmaceutical experiments because it's predisposed to getting cancer, well then you say, okay, you changed the genetic code, and you know that it created a new mouse. Do you know how it created the new mouse? Harvard doesn't know how to make a mouse. You can't go to Harvard and say, build me a mouse. They don't know how to make a mouse. They only know that if you change a little piece of genetic code and you breed the mouse, that it will create a different mouse. So we don't always know how things work. We simply need to know that they do work. So I'll leave you with those thoughts. Well, what do you need to do if you're disclosing an AI invention, right? So the AI inventor says, we initiated certain functions and we got this result. The AI made the connections to a process we don't understand. Well, do you need to show anything else? Do you need to show, for example, if I ask the AI the same question 5 times, that it will come up with the same result 5 times? And so that shows my predictive model must have worked because it keeps coming up with the same result. Does that, should there be some kind of validation that goes on? We'll see in a case we'll look at in a minute, and I'm going to have to end before too long. We can come back to this tomorrow. Is it enough to say, in the case we look at shortly, to say, I used a neural network. I used a neural network to reach my result. Well, what's a neural network? How much do you need to describe the neural network that you use? So we'll look at that in a minute. So that's just another problem. Utility generally probably is not a problem with AIs, right? If you patent an AI and say, my AI does very well at predicting the structure of folded proteins, well, that pretty clearly seems to be useful, right? My AI is useful because it can create folded proteins. Doesn't seem to be an issue. But you have a separate question. What if you have an AI that you use to create new materials, right? So it doesn't get that much attention, but one of the biggest areas for AI in development is materials, new materials, right? Stronger polymers, things like that. AIs create these new materials. Well, what if you tell the AI to create new materials and it gives you a printout of 1,000 different molecular structures and tells you to go make these new materials in your materials making machine and then seeing which ones work better? Well, do you need to show that those materials actually work? How many of them work? What are their characteristics? So you're going to have questions of things that are created and then say, yes, we created them, but do we really know what they do? So that would go to utility questions. And that's really a classic issue in patent law. When do you grant a patent? Do you grant a patent when you create something, or do you grant a patent when you know what that thing does? But that's just a classic issue of patent law that's discussed in various areas, including biotechnology. Now we get to a kind of a core question, patentable subject matter. And really, I think, because technically I should leave off in 2 minutes. I should come back to this tomorrow because this is an important thing in AI. So we have a lot of doctrine. We have exceptions to patent, things you cannot get patents on. You cannot get patents on laws of nature, like the laws of gravity, Newton's laws of gravity. What are they? You can't get a patent on those. Einstein's E equals mc squared. That's a law of nature. You can't get a patent on that. You can't get a patent on abstract ideas. For a long time, the U.S. Supreme Court said you can't get a patent on an algorithm. So there's a borderline between what is an abstract idea and what is patentable subject matter. And because it's a very interesting problem, and there's not that much left to do today, I think I'll come back to that tomorrow rather than try to complete that.